They admit he's not in an office and they're suing under the appointments clause, okay? It's like suing somebody for a DUI, but there's no drugs or alcohol in their system. Trump can't even fire people in the administration who are on probation because judges just shove them back in. The judge continued her hypothetical about UVA law graduates being banned from her courtroom because they're all liars and lack integrity. She's nuts. Elon strikes back. He and the DOJ via the Doge team just submitted a response to this order. The order is from a judge in Maryland, and he sent this one out. He said, hey, Doge, you better give us all these documents by this date or else you're in big trouble. Elon basically responded and said, we're giving you this, that's it. You're done with documents. And if you don't like it, well, you can just go. And here's what the judge said. On March 10th, Theodore D. Chuang, U.S. District Court Judge out of Maryland. This case is J. Doe's 1 through 26 versus Elon at Doge in his official capacity. The judge wrote this before getting told, said, all right, listen, for the purposes of our injunction, Doge shall supplement the court record with the following documents. I want everything, all documents signed by the authorizing government official authorizing each and every one of these decisions. Okay, so give me your emails that put 58 USAID employees on leave. I want to see them. I want to see who put 57 USAID employees on leave on Feb 1. Who made the decision to shut down USAID headquarters and to remove the sign from the building? Judge like, I want to know who's responsible for that. I want to know who decided to transfer USAID headquarters to US Customs and Border Patrol. Like the judge is like, I want everything. I want to know who told you to take the website offline on February 1. Who said put 606 employees on leave? Who put 1,400 more on leave on Feb 4? Who put 2,100 on leave on Feb 7? This is so fun because it's just like a bloodbath every day. Like it's like 58. Okay, pretty good. 57. All right. Okay, now we're shutting the building down. All right, good. Okay, now we're going to give it to Border Patrol. Okay, even better. Now the website's down. 606 more gone. 1,416 gone. 2,100 gone. And then they got rid of 800 service contractors. We can't take it, Judge. There's so much winning. He wants to know who did it all. And so do I. It's amazing. It's like exciting as hell. A lot of fun. So Theodore D. Chuang is going to, I want answer him. Okay, Theodore, give me 1 second, says Elon's team. So they dropped this one today. All right, Judge Weiner, here's our response to your little order. Look, on March 10th, this court ordered sua sponte, and that means on its own. Like nobody asked for this. This judge is just having a conniption fit in his chambers. Probably having his, family call him, I'm gonna get fired, we're gonna lose everything. So he says on his own, after a bad meal, that Elon must produce within 3 days a number of decision documents in connection with USAID. This is Elon and Doge responding. They say, what? The defendants object to this order, which is hilarious, right? It's like you kind of object to other arguments or motions from the other side. Like they file a motion to produce these documents and you object to these, J. Doe's demanding these documents. They demanded, we object, but the judge did it on his own. So we object to you, punk. Mainly because these documents are not even material to these Jane Doe's appointments clause claim. They've got a separation of powers claim as well. But they admit that Elon Musk occupies no office, so he's not relevant, and that Elon has any authority to legally direct USAID or other agencies to take actions. They admit Elon has no say in any of it, and they're suing about Elon. So if they recognize that he's got no office and he has no authority to take any action, that defeats their claim as a matter of law. They admit he's not in an office and they're suing under the appointments clause, okay? It's like suing somebody for a DUI, but there's no drugs or alcohol in their system. It's like their claim is going to fail. They say Elon is violating the appointments clause, but he's not in office. That is only for people who are in office. The Constitution says it's for offices that are established by law. Elon's not in there. So the clause thus ensures that when Congress creates an office and vests it with certain legal power, the person holding that office and exercising that power is selected and approved in a politically accountable manner, right? President is elected, nominates people, advice and consent of the Senate. There's checks and balances there. Whereas here, it is undisputed that a person neither holds any office nor wields any de jure authority, official. The appointments clause simply has nothing to say. They're suing under the appointments clause. Like that's in their pleading. You broke this law. Okay, well, what's your evidence that we broke this law? I don't have any. Okay, well, then your claim fails. Doesn't matter what it is. So if they could fix their complaint and make some other complaint and say, well, well, he should be appointed or something else. As their complaint stands, it's failed. So the order from you, judge, that wants everything from all of our firings, it appears designed to test whether certain actions about which plaintiffs complains, like the judge wants to know, were these things taken by officers of the United States who held legal authority to take them? Okay, and this is so fun because it's just calling the judge out to his face. It's like, judge, can you just stop being a little weenie and just ask what you're wanting to ask? We're not going to give you documents on all that crap. What do you want to know? It seems like you're trying to ask whether these actions were taken by officers of the United States who had the lawful authority to do that. Is that what you're asking, judge? Well, guess what? They were. And plaintiffs, the people suing these does, they bear the burden of proof for this one. And it's a particularly heavy one if they want to seek a preliminary injunction against us. And they have provided no evidentiary basis to conclude otherwise. There is no evidence that somebody made a decision outside of the law. And it's their burden to bring it up, not yours, judge. But we, Trump and Elon, must point out that these facts have no bearings on the appointments clause regardless. Doesn't even matter one way or the other. If an individual is not an officer of the United States and who holds no legal authority purports to take an official action, that might bear on the legal effect of the action, not that the individual somehow becomes a principal officer and requires Senate confirmation, let alone oust them from their roles as officers, like Secretary Rubio in this case, who have undergone Senate confirmation. Now, in all events, Doge says, without waiving their objection to the propriety of any document productions whatsoever in the appointments clause challenge, we are going to give you copies of the orders and the decision documents corresponding to the actions referenced in the order. Now, these documents confirm that the actions indeed were taken, directed, and approved by the appropriate officers or employees. Now, defendants otherwise rest on the current evidentiary record. So in other words, you're getting some materials, but that's it. We're done. We object to your order. This is all you need to know. We're going to provide you with some answers, but we are maintaining all of our objections to this. Like, we're not acquiescing anything. We're not agreeing that any of this inquiry is justified whatsoever. So for these reasons, and those previously articulated in our opposition and at the oral hearing, this court should deny the motion and progress this case to a prompt dismissal. It says these documents were requested from USAID and the GSA. They're not even a party to this case. Now, although the USAID and GSA provided these documents voluntarily, they are doing so without waiving any objections to the future non-party production from this court. So very fun filing from Joshua Gardner, basically shoving it right back in that judge's face after he threw a little bit of a temper tantrum here. I want these documents. Look, here's the thing. They were all done by a lawfully appointed person. So all your little hissy fit whining about this is without merit. Dismiss this case and stop acting a fool. Now, that judge is obviously acting a fool, Theodore, but in addition to him, we've seen that another lunatic judge called Judge Vargas has also gone bananas. And so is this judge. Anna Reyes, a Biden appointee, was presiding over another case that happened yesterday and was furious about a Pete Hegseth tweet. The Biden appointee, who previously stated that the idea of only two sexes, she said it's not biologically correct. A federal judge. Two sexes is not biologically correct. Federal judge heard arguments about the Pentagon's attempt to ban transgender individuals in another hearing. Now, during the hearing, Reyes pointed to a post on X in which Hegseth quoted, and I hope Hegseth tweets like crazy about this issue, at least like 5 trans tweets a day from Pete, because this judge will go nuts. Pentagon says transgender troops are disqualified from service without an exemption. Now, the memo says that U.S. service members who are transgender or otherwise exhibit gender dysphoria are prohibited from military service unless they obtain an exemption. The trans sued, and Judge Reyes is furious about it. During her aggressive questioning of DOJ lawyers, Reyes said that one of the defendants in this case, Second Lieutenant Talbot, has more commendations than books in our library, and asked why she should side with Hegseth, who she said at the time had only been in office for 30 days, rather than deferring to the Joint Chiefs. Reyes said that the Joint Chiefs had determined there's no problem with trans. The DOJ lawyer said, well, you don't really have a decision, Judge. Like, you defer to Secretary Hegseth. He is the Secretary of Defense. It's his job, not yours. You don't get to decide who has a better policy. Reyes fired back, saying that the reason for Secretary Hegseth's decision was informed by 2 studies which actually undercut his policy. She's like, well, he made the decision wrong. It doesn't matter. It's his opinion. He can rely on crap studies if he wants to. She says, we haven't even gotten to the issue of animus yet. Right, here is the quote. Pentagon says transgender troops are disqualified from service without an exemption. The judge then asked the DOJ lawyers if they knew how much the military spends on Viagra. Oh yeah? They said, no, we don't. Well, they spent $42 million on Viagra and compared that to $52 million spent on gender dysphoria treatment over 10 years. So it's like not even the same. So like, you guys are obsessed with your penises. So what if we want to cut the other ones off? Some of you want to grow yours. Some of them them don't want them. It's the same thing. Mannion pointed out that they didn't know how many people they were talking about for each side of the argument, and that it could be the treatment for gender dysphoria is much more expensive. Yeah, it is. I think it's a little bit different, popping a pill, getting an erection for 2 hours or whatever it is, which I think might be a problem. 3 hour, you got to call somebody or something. But the point is, a lifetime of hormones and massive surgery to repurpose the muscles from your arm into a fake genital is a whole different ballgame than popping a little blue pill. Now, Reyes agreed, but maintained that it's obvious that Defense Department spends much more on Viagra than on gender dysphoria treatment. When she questioned the government lawyers on that, Mannion argued that Hegseth was using shorthand. She said, well, look at the words in the policy. Reyes said, no, the judge. Do you really think you can do that? Say one thing in public and then come here to court and say something else? Reyes said that Mannion had until Monday to deliver a declaration from Hegseth that he didn't actually mean all transgender people. There's this judge. I've been using the she pronoun, but I'm not sure. Says his words are that this covers all transgender people. Now, I'm not going to speculate that he was being sloppy. Trump signed an executive order that said, no, you're done with the trans stuff in the military. Government lawyers argued that Hegseth has broad authority to set policies for national defense, and a more specific quote came out like this. Lawyer Jason Mannion pointed out, we don't know how many people we're talking about, and she just, I guess, they're just obsessed with genitals over there. So, in addition to that, this other lunatic judge, Judge William Alsup, who I think is like in his 80s, I read, and probably has no idea what's even happening, but Judge William Alsup described the mass firings as a sham strategy by Trump, and then immediately reinstated a bunch of fired federal workers. Okay, so now Trump can't even fire people in the administration who are on probation because judges just shove them back in. They were on probation. William Alsup described the mass firings as a sham by the government's HR. He said he was a San Francisco appointee of Bill Clinton, obviously, ordered the DOD, Treasury, Energy, Ag, Veterans Affairs to immediately offer all fired probationary employees their jobs back. The Office of Personnel Management, the judge said, was unlawful. One of the most far-reaching rejections yet. Obviously, it's going to be appealed. So we're starting to cross the Rubicon, obviously. A federal judge just says everybody who's on probation who can be fired, like unequivocally, has to hire them back. Got it. Now, a lot of these judges are getting scolded and hammered. This was a complaint that was filed by Chad Mizell, and this one went against Judge Anna C. Reyes. She held a hearing before this last hearing, and she was screaming at them back then. She was asking whether there were only two sexes, male and female. She was not sure how many sexes there were. They said, well, how many are there? She said that there could be anywhere near about 30 different intersex examples. Okay, so biologically, it's not male and female. It's 30, which is crazy. It was during these lines of questioning that Reyes engaged in unacceptable misconduct at this issue and said in her courtroom, she was hammering him about his religious beliefs and then using him unwillingly as a physical prop in her courtroom theatrics. After a long screed about how she believed, this federal judge, that Trump discriminated against individuals with gender dysphoria, she said he was literally erasing transgender people, this lunatic judge. Reyes describes receiving an email suggesting that she develop a relationship with Jesus. Pretty good advice. She then uses this aside as an excuse to randomly pivot to questioning the DOJ attorney about his religious views. Says, well, what do you think Jesus would say to telling a group of people that they're so worthless that we're not going to allow them into homeless shelters? Do you think Jesus would be like, oh, sounds right to me? Or do you think Jesus would say, WTF? Of course, let them in. I'm like nuts, right? Like when I say like these psycho judges, like they're nuts. This line of questioning is deeply problematic for several reasons. Well, first, the question has no relevance to the legal analysis of military policy, obviously. Second, it placed DOJ counsel in an untenable position of either appearing unresponsive or speculating about an incoherent hypothetical alignment with Reyes's personal religious beliefs. Counsel did not fall into that trap, though, provided a professional response that highlights the impropriety of the action and the question itself. The DOJ attorney said, Your Honor, the United States is not going to speculate about what Jesus would have to say about anything. That's a great answer. Your Honor, that calls for speculation. We don't know what our Lord and Savior would say about that. The United States is not going to speculate about this. She probably went nuts. Third, sporadic use of the inappropriate abbreviation WTF. She kept saying WTF during the questioning of an attorney on his religious beliefs sheds light on the severity of this judge's lack of professional decorum. Now, unfortunately, Reyes's misconduct was not isolated to a single incident. The transcript also reveals that Reyes attempted to embarrass counsel by physically directing him as part of a rhetorical rhetorical exercise in front of other attorneys, court personnel, and members of the press. During an exchange about discrimination, Judge Reyes abruptly instructed DOJ counsel, said, "I made a change to my standing order when I was in the back. My new standing order says that no one who has graduated from UVA law school can appear before me. So I need you to sit down, please. I need you to sit down." Wow. When counsel complied with this directive, because he's in her courtroom, the judge continued her hypothetical about UVA law graduates being banned from her courtroom because they're all liars and lack integrity. She's nuts. Only after Judge Reyes used counsel as a physical prop, sit down, did she instruct him to come back up and continue the proceedings. This directive served no legitimate and judicial purpose and transformed an attorney appearing before the court into an unwilling participant in the judge's demonstration. Such treatment undermines the dignity of counsel and the decorum of the courtroom. It also contravenes the rules, saying judges should accord everybody proper care. Judge Reyes and her actions diminished respect for counsel, creating an intimidating environment. The physical direction was for dramatic effect, not for anything that was relating to anything proper in court. And so you should act in a manner that promotes confidence. And so we respectfully ask that you address these violations in future court proceedings. We need an independent and impartial judiciary, not one filled with psychopath Democrat hacks who speak like they're texting 8-year-olds. WTF in the courtroom, screaming about Jesus in there. Absolutely nuts. So that's the Judge Reyes there. And Elon, in spite of all of this, in spite of Doge coming after him and Trump and USAID and all of them, they're not stopping at all. Elon's going after the IRS now. 20% staff cuts coming soon. Here's what's being reported over from the Washington Post telling us that on Thursday, the Trump administration removed the IRS service top lawyer and rolled out plans to downsize 20% of the agency's staff. Oh no. It's a good start. William Paul, a career official named to the position in January, will be replaced by Andrew DeMello, who was nominated to be the Education Department Inspector General before. 3 people speaking on condition of anonymity, not authorized to speak to the media about any of this, but it's happening. Also, Doge officials instructed the acting IRS commissioner to eliminate 18,000 IRS jobs gone by May 15th. Afuera. The Tax Compliance Department would have the largest job cuts, 8,200 gone. Taxpayer Services, 3,200 gone. These moves are only an initial phase of the job cuts. Gavin Kleiger, a Doge software engineer, has signaled to agency leadership plans for further headcount reductions, according to 2 more. The internal reshuffling comes as career staff clashed with Doge officials and battle attempts to access information, but they're coming in hot. All 5 people who spoke on the matter said Paul's ouster provoked concerns. All the career staff are already freaked. Doge O'Donnell, a civil servant who spent several decades at the agency, left last month the IRS after a disagreement with Trump's new people. Spokespeople for the IRS and Treasury declined to comment. Doge has sought to use IRS records as part of its efforts to reduce fraud. Trump administration moving ahead with plans to reduce even more. Some saying maybe 25,000 additional employees could be axed on top of 12,000 who've already left. Highly unusual, they say, to remove an acting chief counsel, according to former acting chief counsels. While the chief counsel is a political appointee who often leaves, they're typically experienced career officials, which is exactly why they need to go. So Elon not slowing down, striking back, telling a judge that we're going to give you what we give you. You don't need any more. Stop raising these arguments on your own. We object, and the cutting will continue. So we'll keep our eye on this, on these wacko judges. Thanks for subscribing and joining as we do.